Okay, folks, let's get started. In this video topic, I'm going to talk about complicity theories of criminal liability. The indictment doesn't read charged with complicity. The indictment reads robbery. You are charged with robbery, and then the government's proof will point to another person as the main actor and the defendant as a supporting player. So it's a complicity theory of charging, let's say, robbery, whatever the underlying crime is. So what does a person have to do that would support a conviction for a crime under a complicity theory? Here's the key idea. The defendant has to help the primary actor. You're asking about helping. Brings to mind a familiar television commercial from my childhood.
Grandma, can I help you make your special fried chicken?
If you can keep a secret, I use shake and bake now.
You do?
Sure, I'll show you. First we shake, then we bake.
Mother, why isn't my fried chicken as crispy and juicy? I want your recipe.
Grandma didn't fry.
But it's crispy like fried.
Can I help? It's shake and bake, and I help.
Shake and bake coating mix. It's better than frying.
So there you have the central idea of complicity theory. And I helped. Now let's talk a minute about some of the terminology in the area. There's a historical trend here, and we've seen this trend before, for instance, in voluntary manslaughter. The trend is this. At common law, complicity was typically complex and category-oriented. On the other hand, modern criminal codes tend to use broader, more general categories, broader sweep. So, for instance, in the complicity area, the old categories were, first of all, there was principal in the first degree. That would be the actor or perpetrator, him or herself, and at the scene of the crime. The principal in the first degree had to be the main actor at the scene of the crime. Principal in the second degree would be present at the scene of the crime, but not the person, not the main actor, not the person who committed the criminal acts. And over time, presence could be constructive, so it would include the lookout down on the corner, not just the person right at the scene of the robbery. This is also known sometimes as an accessory at the fact. Then there was the world of accomplices. Apart from principals, there were accomplices. There were accomplices who were not present at the time, and so there are accessories after the fact and accessories before the fact. So here's a cartoon to consider for these different roles. Let's imagine these guys, they see she's got the body and the gun, and what if they say, be our guest, we've got a hole anyway, we don't mind covering it up. Are they then accomplices to murder after the fact? Under the traditional terminology, you might be able to charge these guys with murder as an accessory after the fact. Today, all accomplices are treated alike in terms of the crime of conviction, except for accessories after the fact. That being said, the punishment patterns are a bit different. The actual punishment that a judge would impose would tend to be different for the main perpetrator and the other participants who were at the scene. And you see some examples here from the North Carolina Code. Now we've talked about what the prosecution has to prove for the objective element for a complicity theory. You have to help. Let's now walk through a problem as our way of talking about the mens rea for a complicity theory. Now, as with other inchoate crimes, here's the big picture. The courts often become pretty demanding on the mens rea side as a rough way of compensating for the easier prosecution case on the objective elements. So let's use this problem. Bob goes with his friend Max. Max is 21 years old. They go to the home of a fellow student, Susan. They both suspect that Susan is less than the age relevant for statutory rape. Max brings a gun along in case Susan's older brother John happens to show up, because Max knows that John objects to the relationship. Now, Bob knows that his friend Max has the gun, but he's decided what he'll do is he'll stay out in the car outside, and he's going to be lookout. He'll blow the horn if John shows up, but he falls asleep behind the wheel of the car. Then he wakes up, hears a noise at the door, realizes, uh-oh, John is now home. He tries to blow the horn, but there are no keys in the car, and this is one of those neat, newfangled electric cars, and no sound. He's trying, no sound. John enters, Max shoots him, and he dies. So what's going to happen here? First, let's ask, is Bob guilty of rape through an accomplice doctrine, an accomplice theory, at common law? First, let's think about the objective element at common law. Bob actually has to help or encourage. Typically at common law, he has to be successful. So if he's trying to blow the horn and it didn't work, then he's not helping. Probably we could say he's not guilty of rape at common law, unless the prosecution gets this theory in front of the jury. Did the fact that Bob was sitting outside in the car give Max inside the confidence to go ahead and commit the crime of statutory rape? So what about the culpability element for the statutory rape charge? Well, the common law requires that the accomplice act intentionally. The most common law judges, like Learned Hand in United States versus Peony from 1938, say that what this means, intentional conduct, is purposeful. The accomplice has to, quote, associate himself with the venture, participate in it as something that he wishes to bring about. There's a competing way of looking at this at common law, embodied by Judge Parker in Bakun versus United States from 1940, who says there's no need for the accessory to have a stake in the outcome. The accessory, quote, may not ignore the aims of the perpetrator. So knowledge is enough for these judges. So there's a bit of a common law disagreement, but the most common position is that of Learned Hand, and that is purpose has to be the culpability level for the accomplice. Okay, so we've talked about the culpability level that the prosecution would have to prove when it comes to the statutory rape charge. What about the culpability level if the charge against Bob is murder? If we're at common law, if we're talking about unplanned offenses, it was handled like felony murder. If you're guilty of rape, under whatever theory, therefore you're guilty of the unplanned crimes that come along, so long as they're the, quote, natural and probable consequences of the planned crime. Today, few jurisdictions follow this expansive doctrine. Unlike felony murder that was expansive and remains very popular, this version of complicity was very expansive, but it is an unusual situation now. So it's much more common to have states now follow something like the Etzweiler versus State case. Remember, in Etzweiler, the defendant has a drunk friend and says, give me your keys, I want to drive. And so he says, sure, here are my keys, says Etzweiler, hands his keys over, the friend goes out and drives and, of course, kills someone. Is Etzweiler an accomplice to homicide? The court ends up saying that there's no criminal liability for this defendant on an accomplice theory because of our old friend elevation of mens rea. The idea here is that you have to elevate the mens rea for the underlying crime here. It would be some form of reckless homicide, not intentional homicide. But you have to elevate that crime up to purposeful for the accomplice. And so under the Etzweiler outcome, the court says no reckless homicide on an accomplice theory here. Now, how about under the Model Penal Code? First, let's talk about the objective element. What do you have to prove for a complicity theory of, let's say, statutory rape under the Model Penal Code? Well, under the complicity statute, section 2.06, subpart 3, the defendant has to, quote, aid or agree or attempt to aid. This is true to the subjectivist view of the criminal law that runs throughout the Model Penal Code. Does the prosecution have to prove that Bob only has the purpose that Max engage in the conduct element of his crime, that is sexual intercourse for statutory rape? Or must Bob also have the purpose that all the elements of the crime be completed? Here, the model penal code again splits the difference, as we've seen in the past when it comes to elevation on the mens rea for inchoate crimes. So when it comes to result elements, Model Penal Code 2.06 subpart 4 says that there is that if you're talking about causing a particular result as an element of an offense, then there's no elevation of the mens rea. As it puts it, the kind of culpability, if any, with respect to that result that is sufficient for the commission of the offense. That's what the prosecution has to prove. On the other hand, for circumstance elements, the Model Penal Code is silent, and it may be that it requires some elevation. We'll talk about this more when we get together, and about the reasoning for the Model Penal Code splitting the difference in this way once again. But remember, the basic insight here is that at common law, we're talking about the courts getting more demanding on the mens rea side, because over on the actus reus side, there's less that the prosecution has to prove in terms of the action of the helper as opposed to the principal actor. So work on this a little bit more, do a little bit more reading and thinking, and we'll get together to talk about both the objective and the culpability elements for complicity theories of liability. See you then.